All right, everybody. This is not something I typically do. It's a pre-recorded piece because I'm talking with two attorneys out of Alberta who are going to, on the one hand, tell you who they are and explain what they're doing, which is, as far as I understand, from a very cursory 50,000 foot overview, the largest class action lawsuit against the government of Alberta. I might even be misdescribing it, but we'll get there in a second. Might you both be able to introduce to the world who you are?
Sure. My name is Jeffrey Rath. I'm the principal of Rath and Company Barristers and Solicitors, and I was lead counsel on the Ingram case, where we succeeded in having Justice Romaine of the Alberta Court of King's Bench declare every single public health order issued by Deena Hinshaw throughout the currency of the pandemic in Alberta to be unlawful.
Eva, actually introduce yourself before I even ask my question there.
Sure. My name is Eva Chipiak, and I'm an attorney lawyer here in Canada working with Jeff Rath, and I'm really excited to be involved in this class action lawsuit. There's been lots of activity going on in the legal field, and I think this is going to be a very interesting case.
Now, back it up just to what Jeff said 2 seconds ago. Am I living in a bubble, or did I not hear that Deena Hinshaw's health orders or whatever the decrees were deemed unconstitutional?
No, they were deemed to be ultra vires, the Public Health Act. Okay. So what that means, the orders themselves were, what you know as a recovering attorney, that what that means is the orders themselves were declared illegal because Deena Hinshaw did not have the authority under the Public Health Act to issue all of the orders she issued throughout the pandemic.
And that, I mean, that's an important distinction that I'm going to highlight. It's not that they were lawfully, regulatorily adequately issued, but unconstitutional or charter violations. They were ultra virus, the statute that empowered her in the first place.
But yeah, which makes it, to me, is even more exciting, and that's what gives us such a strong footing for our class action lawsuit, is that it wasn't even that they were validly passed regulations to begin with and then subsequently found to be unconstitutional. They were found, the court found that Deena Hinshaw effectively shut down the entire Alberta economy on the basis of orders that were completely illegal.
Well, and that would say ultra virus, the legislation that empowered her to do it. I've got to ask, not to nitpick. So, what was the rationale? Was it that it didn't go through a public speech and debate?
No. This is what also gives us such a strong footing for our class action lawsuit. And I have to say, the justice in the case was very unhappy with me when I made this characterization during the case. But I likened it to Deena Hinshaw, rather than acting as a public health doctor, which is what we thought we'd hired her for, was in effect acting as a cocktail waitress by going into Jason Kenney's cocktail cabinet and presenting them with a menu, of drinks to choose from. So, the least fizzy on the bottom and the most fizzy on the top, and invariably they'd pick one in the middle. And from a constitutional perspective, what that means is that it was clear that what Kenney was doing was not choosing the least intrusive or the least impactful public health measure that would have worked. He was constantly trying to strike this balance by picking the one in the middle that would achieve that rarest of all political feats, which was to equally anger people on both sides of the issue. So obviously, those of us on the freedom side, wanted as few restrictions as possible. We were of the view that locking healthy people in their homes, denying healthy people the ability to go to restaurants, shutting down businesses and telling businesses that they could no longer serve healthy people in their businesses. We felt that was that went well beyond the scope of what she was empowered to do under the Alberta Public Health Act. We also made a number of arguments as to the constitutionality of the of the provisions. But interestingly, at the end of the day, the justice, at our urging not to, issued what amounted to an 80-page constitutional ruling saying, notwithstanding the fact that I found all these orders to be illegal, I'm going to tell you all the reasons that I would have found them to be constitutional had I not found them to be patently illegal. So it was a very bizarre, I could see you're puzzling this out as a lawyer. I mean, the best way to put it was, I had a really good laugh one day when a CBC reporter called me, and the CBC reporter was going from their talking points, which was, oh, well, but the court found these to be unconstitutional. And I said, no. I said, you have to understand from a legal perspective that everything she said about the constitutionality of the orders went out the window the minute she found them to be illegal, right? So, and I was kind of laughing at the CBC reporter because I said, like, just think about what you just said. You know, you said that didn't the judge say if the orders weren't patently illegal, she would have found them to be constitutional? And I said, I said from a layman's perspective, that's like saying, boy, if I had $6 million, I'd go out and buy a really nice boat, but I don't have $6 million or a boat.
Well,
You
no,
know,
but
so in legal context, the Latin term for it is obiter dicta. So all the constitutional rulings in the case were obiter, and the only binding ruling that she issued was that every single order issued by Deena Hinshaw under the Public Health Act was ultra vires, because she didn't exercise her decision-making capacity as a doctor. She was in effect, acting as a political flunky or consultant, going into cabinet with, a range of policy options, then letting Kenny's cabinet pick one of the policy options, and then they would pretend to implement it as a public health order, as opposed to a pure political decision being made by Kenny and company.
And just to clarify, the CBC journalist said that the judge had found the orders constitutional.
Well, but again, the way the question was framed, it's like, well, Mr. Rath, wouldn't you agree that if the judge hadn't found the orders to be patently illegal, the judge would have found them to be constitutional?
No. I think you just might have said unconstitutional before and not constitutional, because the CBC journalist's point is that, they said they were constitutional,
right?
Had they not been illegal. And I mean, I say even not a better analogy, but like another example would be, it would not be illegal, it would not be unconstitutional for a police officer or, let's say, a law enforcement to put you in jail, but it would be ultra vires for a teacher who doesn't have that authority in the first place to do it. Not unconstitutional because it still can be done, but just totally ultra vires the powers of whoever did not have the authority to do that.
Yeah, I think that's ignoring the niceties in and around citizens' arrest. I think that's probably.
I'm just trying to. The idea was that the measures might have been or would have been constitutional had they been lawful, had the person been lawfully empowered to.
But there's a broader issue here, though, and it was one that we advocated quite strongly. And again, it doesn't matter in the result because the judge found all of the orders to be illegal. So from the standpoint of the class action lawsuit that we brought on behalf of all business owners in Alberta, or people that were, that suffered economic losses as a result of the illegal Hinshaw orders, for us, getting the ultra vires ruling as opposed to the constitutional ruling was the home run, because there's actually a section of the Public Health Act that says that you can't sue, it's 66.1, that you can't sue the government or the chief medical officer of health or anybody with regard to any actions that they undertook under the Public Health Act. So, of course, because it
was ultra vires, she loses whatever immunity.
Under the Public Health Act. Right.
And I also want to pause right now. I have put Deena Hinshaw on blast many, many times. I'm not putting words in your mouth, and I don't expect you to agree with me. In my view, she's the absolute mentally unhinged psychopath who was sitting there hand washing with the alcohol, takes the mask off her face with the pinkies, puts it on the table, spritzes. Good afternoon, everyone. And then puts the mask back on, disinfects her hands. She was the one who also lied about the 14-year-old kid, purportedly Alberta's youngest COVID victim, who was actually stage 4 brain cancer in a coma when they tested him for COVID and then died. And then she attributed the death to COVID and then apologized for it a few days later when the sister spoke out. I do not need you to affirm or confirm or agree with anything I just said.
But I will say that, I mean, I advanced a number of those arguments in court and cross-examined Dr. Hinshaw, with regard to a number of those issues from a credibility perspective. I mean, what I've been saying after the ruling, and I think I have, sound substantiation in law, how grossly incompetent do you have to be as a public health official not to know the limits of your statutory authority, where, you're literally issuing orders that are affecting billions of dollars worth of trade in the province of Alberta, destroying people's businesses, destroying their livelihoods. I know people who were wiped out economically that literally felt that they had no option other than to commit suicide after their businesses were destroyed, by these ridiculous lockdown orders that, from a public health perspective, were not justifiable. So, So those are things that I'd like people to keep in mind. I'm sorry, Eva wanted to make a point.
Yeah,
So
yeah. I just wanted to reinforce, because when people hear the word illegal, they often think of the criminal code, and I just want to enforce. You've heard all of us say the word illegal, and it's correct. But how I liken it, I think it makes sense for people. It's administratively it was illegal because our elected officials only have the authority to do, as we've all been saying, what's in statute, what they're designated, what they're allowed. They've been given powers to do. So if they go outside of that, 100% it's illegal, but it's not something to think that it's a criminal code, but it's very serious. It's a very serious matter. And there's a reason that they're limited to certain powers and authority. And yeah, go ahead.
Maybe this is the best analogy. Small claims courts cannot issue injunctions. So if a judge at a small claims court comes down and issues an injunction, I guess that would be similarly ultra virus in that they don't have it wouldn't be unconstitutional for a superior court judge to issue an injunction, but I hope that's a good example. And yeah,
I think you're spot on. And I mean, nobody's ever suggested, I've certainly said publicly that I think Deena Hinshaw was one of the most incompetent public health officials that we've ever had administering public health in Alberta. But we're not suggesting, that what she did in promulgating these orders that were outside of the scope of the Public Health Act were criminal, or that she's ever been adjudicated as being a criminal. She's basically been adjudicated as being an incompetent that didn't know the limits or extent of her own authority under the Public Health Act.
Yeah, and I'll say I think she's a raging psychopath who was drunk on the power, period.
Well,
and acted accordingly. So bottom line though, this is wild that I didn't even hear about it. All of the public health measures that she declared, purportedly under the authority of the Alberta Public Health Act, were declared ultra virus beyond the scope of her authority under the act.
No, that's correct. But just to be clear, and from a very narrow technical perspective, they were all of her orders up to a date and time of our pleading. And then there was another case called the CM decision, which was actually quite entertaining. And I always want to give a shout out to my friends Orlo Kelly and Sharon Roberts for going forward and paving the way on our ultra vires argument, because they were on the union side trying to remask kids in schools, if you can imagine it, after the restrictions were lifted. And they went into court in front of a Justice Dunlop and argued that the demasking of the children order was ultra vires, the Public Health Act, because Deena Hinshaw didn't make the decision and Jason Kenney made the decision. Right? So that wasn't their intended result. And of course, it was really funny because the judge in the case obviously had a good sense of humor. And he said, I can't grant you your constitutional remedies, but if you really want me to declare these orders to be ultra vires, the Public Health Act, I'll do that. But that having been said, I'm never going to remask the kids because we moved on in time. The pandemic's where it's at. Public officials have found that, the masks are no longer required for the safety of children in schools. So I'll happily grant an order saying that Deena Hinshaw's orders were ultra vires, the Public Health Act, because she, in effect, was not the decision maker. But I'm not remasking kids in schools and off with you, right? So and again, I always want to give them credit for paving the way with the CM decision. I'm sure that they'd want to be given credit for their fine work there.
Well, so this is amazing. Now I see exactly where this is going. All whatever the measures, limited temporally, declared ultra virus beyond the scope of her authority, unlawful, and now that opens the door to the class action lawsuit that you're filing against the government of Alberta.
That's correct. Because, if you look at it from two different perspectives, we have the Section 1 Bill of Rights argument that property rights are protected by Section 1 of the Alberta Bill of Rights. And then a standalone argument is a negligence argument, that it was completely negligent of the Alberta government and Deena Hinshaw and others to shutter businesses across the province on the basis of orders that were illegal and weren't properly promulgated under the Public Health Act, and in fact weren't medical decisions, but arbitrary decisions being made by Jason Kenney and his COVID cabinet involving lots of other people who thankfully have been turfed out of government, including ministers Copping and Shandro, who, well over drinks would agree that, this was the best way to go, and that Alberta business owners should be deprived of their business revenue and their businesses should be destroyed for the benefit of society as a whole, without any proof whatsoever that any of these lockdowns or vaccination orders or vaccine passports or any of that garbage that they were stuffing down people's throats were in fact going to have any effect in favor of, in abating COVID transmission throughout the pandemic. So, we obviously think we have a very strong argument on the negligence ground, and then on the and again, these are technical points, but on the Bill of Rights argument, the leading case on the Bill of Rights and property rights in Canada is a case called Authorson at the Supreme Court, which I've been advocating for years be legislated out of existence. Because what Authorson found with regard to the Canadian Bill of Rights is that the property rights protection in the Bill of Rights was never intended to be a substantive protection. It was only a procedural protection. So if something went through the requisite procedure, 3 readings, and in Authorson, the government of Canada actually specifically legislated away a court victory by veterans whose pension funds had been maladministered by the government of Canada. And because the outcome was going to be in the billions of dollars of money that was owed to our veterans, Parliament actually passed a law saying, notwithstanding the fact that you won this case, we are declaring as a matter of law that you're not entitled to the billions of dollars in excess interest that you were due, but for our gross incompetence. And when the veterans took this case to court, they'd won all the way along, but along comes a Supreme Court that says, oh, no. The only right there is a procedural right, and the procedural right is limited to the matter going through 3 readings of the Parliament of Canada and it being proclaimed into law. And once that happened, that was the end of the procedural process, right? Well, the great news for us in the Ingram case is that the court clearly found that the orders were ultra vires, so they have no procedural protections with regard to the protection of property rights in the Alberta Bill of Rights. So our position is that we win on both grounds, but we see them as independent grounds. We either win on one or another to get damages in the billions of dollars on behalf of all of the citizens of Alberta who were so egregiously affected by these orders. Like, think of, like Rebecca Ingram as an example. She lost her gym over this. She was forced to sell her gym and all of her equipment at a loss, to keep from going into bankruptcy because of the damages that she sustained as a result of these shutdown orders. Her gym had never been found to spread a single case of COVID. There'd never been an issue with the cleanliness or the hygienic nature of her gym. She had plans in place in a very large facility for social distancing so that people wouldn't be in contact with one another. There was absolutely no empirical reason to shut down her business, but they did, and they almost bankrupted her. Chris Scott, for God's sake, was hauled away in handcuffs.
Let me ask you this.
Can I just add on to Chris Scott? I went out there, and this is in Mirror, Alberta. Anybody in the audience ever heard of it? You get off the highway and you drive for at least half an hour into a field in the middle of nowhere. He's got a coffee shop.
No, Central Albertans would take issue with the middle of nowhere.
Sorry.
The middle of Alberta.
but when I physically went out there, I was in shock that because he was targeted in the end, like Jeff was just saying, that he was escorted out in handcuffs. And when I was out there, I could not believe the amount of effort they would have taken. There's room there for people to go and have a coffee and get some sustenance.
They're making an example of non-compliant citizens. But now,
of course, and that was the whole problem. Be afraid, be very afraid. And if you're not afraid enough, we'll seize your bank account, shutter your business, haul you away in handcuffs. Be afraid.
No, but this is going to be, or this is a proposed class action. Has the class been certified yet?
No, and where we're at now is we filed a statement of claim. The statement of claim is can be perused by anybody that's interested online at our website. Evan, if you want to tell people what the...
Yeah, so if you go onto the website, Rath & Company, click on the business class action link, you have the statement of claim.
I'll simplify it. You'll send me the link and I'll put it in the pinned comment below this
Sure,
video.
absolutely.
And you also see the Ingram decision, which I think is important. And there's an online form there, so anybody in Alberta that thinks they're affected can sign up, and then we'll be providing updates as we go through it. So it's really important to let us know so that we can get in contact with you.
And
But
now
again,
the,
go ahead.
the proposed class is going to be anybody who's presumably anybody who sustained financial loss, property loss as a result of any one of the COVID public health orders that was declared ultra virus.
Exactly.
Is this not going to be one of those cases where it's going to be like virtually impossible to individually adjudicate on everybody's damages because they're going to vary so widely depending on what?
Well,
they
that's the issue with with class actions generally. But I mean, what we're hoping to do by having people, because people don't need to register to be part of the class action. So the way the class action law works in Alberta is that upon certification, you're deemed to be part of the class unless you opt out, right? So as of now, our firm is representing every single business owner in the province of Alberta who has lost revenue and suffered economic losses as a result of the unlawful COVID orders that were issued by Deena Hinshaw, right? So that's what everybody needs to keep in mind. Certification will gel that. But anyway, we're and we're continuing to move forward on certification. We see certification as being almost a pro forma step in this proceeding, given the fact that the liability has been well established by the Ingram decision, where the orders have been found to be unlawful, right? So we have a cause, illegal orders. We have in effect business bankruptcies across the province and business losses across the province. We think there's very clear linkages there. That will be readily apparent to the court. And of course, what we're looking forward to is seeing the degree to which our friends in the Alberta government legal services team, go out of their way to try to turn themselves inside out to deny people who suffered egregious economic losses, be denied their compensation. What we're hopeful of is that journalists will start asking Danielle Smith what her position is with regard to this lawsuit, and whether she intends to fight this tooth and nail to the detriment of all of her constituents who elected her leader of the Conservative Party, or whether she intends to engage in a process of reconciliation and settlement with our office in order to come up with a settlement that would satisfy the needs of all of the people that were destroyed by these ridiculous orders.
Who's the lead plaintiff thus far?
Well, the representative plaintiffs in this case are Christopher Scott, or Rebecca Ingram, and Chris Scott.
Okay.
Of Whistle Stop Cafe. So, we thought they were both very good representatives of what transpired in this province. As I said, I know countless other business owners that we've been in contact with, and their stories are absolutely heartbreaking, Viva. I mean, we're talking about, literally, in one case, a person that I've known for years in Edmonton took their own life because they expanded their business in 2019 in a normal business environment. All the lending was in place to cover that. Their normal cash flows more than met their lending requirements. But then along comes Deena Hinshaw without a thought and shutters all of these businesses, disrupts all of that cash flow. All of a sudden, somebody's offside on millions of dollars worth of lending covenants, and their bank refuses to renegotiate. And it was Alberta Treasury Branch, incidentally, in the case that I'm referring to right now. Alberta Treasury Branch refused to renegotiate their loans, notwithstanding the fact that they were effectively being bankrupted by the government of Alberta. And this poor individual felt the only way that they had forward to save whatever property that they had left was to commit suicide for the benefit of their family, so they could at least collect their life insurance.
That will enrage me beyond anything, there's nothing that can ever be done to even begin to right that injustice, people don't always fully appreciate. I was still practicing when this happened, and I had a restaurant client, and other than the fact that they come in and say you're shut down indefinitely, everybody's got perishable assets that you're not going to get back. And then they say, okay, well, you can open as of a given date, but put in plexiglass, put in all this crap. And then they just arbitrarily, with the snap of a finger, say, well, that's no longer good. You've just invested $10,000, $15,000 in this. You were planning to open. You've got perishable assets again. Now you're shut down again. It's just willy-nilly devastation. But not every...
Oh, sorry.
Oh, no, I was going to say, not every province has the benefit of this ultra-virus ruling. In fact, I think we don't. In Quebec, at least, a lot of these idiotic public health orders have been ratified by the court.
Well, I would suggest to legal counsel in those other jurisdictions that they look into the nature of the political process and the machinations behind the scenes that led to the promulgation of these health orders. And I think that, you would probably find upon investigation in most jurisdictions, these orders were issued in a manner that was ultra vires the public health statute. Like what they did in Alberta, and this was just shocking to me as a lawyer. Section 29 of the Public Health Act in Alberta, on a plain reading, is like a typhoid Mary provision. You can shut down a business or lock somebody up in their home if they have a known communicable disease, and notwithstanding the fact that they're known to, be communicating this disease to the world at large, or thumbing their nose at public health officials and saying, well, I don't care that I've got typhoid. I'm going to run around, the East End of London and make everybody sick if I want to. Section 29, to my way of thinking, was meant to, for them to be able to apprehend those people, lock them up in their own house for the protection of everybody else because they have a known communicable disease. It was never intended to lock healthy people in their homes or tell healthy people how many other healthy people they could invite into their house for Christmas. Wasn't intended to tell some of the Alberta orders were literally this stupid, telling us as an adult, that we could only have 2 friends that were our designated friends throughout the pandemic, and we couldn't have friends outside of our designated friend group.
I was in Quebec. We had the curfew. We couldn't have indoor gatherings. I mean, I was at the worst of the worst. But actually, just one question: the ultra-virus ruling, has Alberta not pledged to appeal that, or are they not?
No, that's and I actually have to give Danielle Smith props for that. There was obviously quite a bit, from what I understand, of the internal machinations of the Alberta government. There was obviously quite a bit of pressure from the bureaucrats within the administrative state to appeal that ruling to the Alberta Court of Appeal. But they were overruled by saner heads prevailing and saying that, in effect, acknowledging that they shouldn't be appealing or dragging out, the issue when so many people were clearly hurt. And on the face of the ruling was patently correct. It was confirmed by 2 justices of the Court of King's Bench, Justice Dunlop and Justice Romaine, both very well respected jurists. And I think that even though there was a lot of pressure, from the Coppings and Chandros and Jason Nixons and Jason Kennys of the world in Alberta politics to appeal the decision, I think Danielle Smith showed remarkable leadership and fortitude in standing up to them and not having the matter appealed on her watch.
So it's, as we say in Quebec, chose jugée, it's res judicata.
Oui, c'est ça.
Très bien.
That's fantastic. So there will be no risk on that. And then the question is what impact it's going to have on the class action. That's wild, and that's actually kind of good news. So it's nice to have a little bit of good news.
Yeah, it's always nice to hear one for our side, when you hear so much of the idiocy going the other way. I mean, what still just boggles my mind is the degree to which people within the administrative state are still running for cover and trying to hide behind the fact that everything they told us about the science has been proven to be wrong from day one, right? Oh, get vaccinated because you won't get sick. Oh, well, you'll still get sick. We lied about that. Oh, get vaccinated because you won't spread COVID and kill grandma. Well, we were wrong about that too, right? And just all the way through, pushing these narratives that were proven to be false, that were being fed into all of these various public health decision-making bodies, by Theresa Tam and, the sort of Central Committee on COVID Correctness, where they were wrong time after time after time after time and did untold billions of dollars worth of damage to the Canadian economy. Like, I think you could put the damage in the trillions. Look at the debt that Trudeau racked up through COVID because of the lack of parliamentary supervision, him being able to sneak through an election in 2021, shortly after engaging the psychological warfare division of the Canadian Army, to direct psychological warfare operations against the Canadian people as a whole, in advance of an election. I think that's the first time that's ever been done in Canadian history. So, I mean, just look at the foolishness that we've been living with through all of this, the egregious violations of rights, that we've all suffered. And, ask at what point are we going to see recompense? And we obviously hope that this class action lawsuit that we're taking forward on behalf of Alberta businesses will lead the way, and come to a clear policy direction across the country. And the bureaucrats need to be told that it's time for you are all wrong. You made completely anti-human and evil decisions throughout the pandemic. We're not listening to any of you anymore with regard to anything. And we need to find a way to compensate people who literally had their personal savings wiped out. I mean, the government, in essence, with the Alberta businesses, Deena Hinshaw and the government of Alberta were taking the position, oh, we'll just shut these people down. They can go through all of their savings to keep their businesses viable. They can, they can find people to lend them money that'll keep them going and incur all kinds of debt to keep from, from going bankrupt. They can do all of these things because we've just declared it a whim. We've waved our little fairy wand in the air and, and have taken steps to steal property from business owners through these absolutely ridiculous anti-human orders.
It's not just that they were wrong. It's that in many cases, I'm convinced they knew they were wrong or had no reason to think what they were saying was right, and nonetheless did it. And it was the biggest Milgram experiment that we've ever experienced in real time. Where can people follow? I mean, I'll put the link in pinned as well, but just mention it. Where can people follow you guys to keep up with updates on the class action?
Well, they can follow us on our website that we're going to put the link to at the bottom. We're going to be putting, every time that there's an actual step taken, in the action, we'll post a news release. But on top of that, we'll be sending out, probably bi-monthly, progress reports and letters, talking about the action, advising people of what their rights are under the action, telling stories of people that agree, in terms of how they suffered through the pandemic. So people, that people can fully understand and internalize through, sharing their stories of what they went through, how truly evil and anti-human, this entire process was, and how obviously, what they suffered cries out for justice and cries out for compensation. So that we'll be doing that, every 2 to 3 weeks, as well as keeping people updated on a going forward basis with steps in the lawsuit, posting of new pleadings. The next step for us is we'll be filing our application for certification, with supporting affidavits and legal briefs and so on. And we'll be posting all of those on our website, for people to read and see that, to watch the process unfold, et cetera. So that's the plan going forward.
Amazing. I'm going to say thank you for doing it, and thank you for bringing it to my attention so that I can now bring it to the attention of as many people as humanly possible. To be continued.
Yeah.
Well, it's such a pleasure to meet you today, Viva. It was a real pleasure, and thank you for the interview. We're grateful to have been here.
My pleasure. Thank you very much. Ending transmission.